Hello friends, and welcome to the virtual study room of Zaware's Professional Academy, India LLP, the Pioneer Academy for CA guidance and coaching for the past 40 plus years. Today, we begin with our subject, that is mercantile laws. Mercantile laws, new subject indeed. Now, many people approach something new with a little amount of hesitation, little amount of fear. Why is that there? Because they don't know about it. So we approach it in a slightly hesitant manner. But as we get acquainted with it, we start liking it. It becomes interesting. And so it will be with the subject of mercantile laws. Now it is new for all of you. But as we begin to study it, as we begin to understand it, believe me, it is one of the most interesting and easy subjects in CA course. So let's begin with understanding what is the meaning. Now let's first say our subject is mercantile laws. Let's go to understanding the meaning of law, okay? Then we'll go on to understand the meaning of mercantile. Now the word law can be used in any number of ways. For example, let's see over here the different ways in which the word law is used. We have the first sentence, I am a student of law college. She is studying mercantile laws in CPT. He has been in the practice of law for the past 10 years. The judiciary is the law protecting organ of the government. We need to follow and obey the law of the land. Now, if you observe, the word law has been used in all these 5 sentences. Do they mean the same thing in all the sentences? No. Correct? So let's understand what the word means. In the first instance, it is talking about the name of the college. So it's used as a proper noun. Second, mercantile laws. Here, it means the name of the subject. Third, practice of law. Here, it is referring to the profession of law. Fourth, law protecting organ. We are talking about the third organ of the government. We have the legislature, we have the bureaucracy and the judiciary. So here law, we mean talking about the organ of the government. And we need to follow and obey the law of the land. Now what is the meaning of law of the land? Law of the land means the rules and regulations which are needed for the governance of a country, to maintain stability, to maintain security, the set of rules and regulations. So you have seen here that the word law is the same, but it is used in different contexts to mean different things, right? Now, let's just understand what we are going to study in your coursework, okay? First, we have the Indian Contract Act of 1872, where we will be understanding the nature of contract, consideration, essential elements of a valid contract, performance of contract, breach of contract and remedies for breach, as well as 2 special types of contracts being contingent and quasi. That's going to be our first act, the Contract Act, which is actually the base of all the other acts. Then we have the Sale of Goods Act of 1930 and the Indian Partnership Act of 1932. This is your basic syllabus for the subject itself, okay? So here again, when we have to understand Indian Contract Act being part of mercantile laws, so again we come to the base, that is laws. So what is the meaning of law? Law means, now see, for example, in our families, we have certain rules, certain regulations, certain norms or ways of behavior, correct? Now, who sets these rules and regulations? It can be a simple thing that you have to return home at this particular time at night, or you cannot stay beyond this time outside the house, right? It's kind of a rule of the house. Now, who has set the rule? Have you set it? Or is it someone who is higher than you, maybe your parents, who have set that rule? right? So it is someone who is higher, correct? But there are some set of rules which you have, which are set by somebody higher than you. And why do we need it? We need it so that there is some amount of discipline, there is some amount of order, right? And if you don't obey those rules, what is going to happen? Yes, you may be grounded in the sense that your parents will refuse to send you out of the house if you don't obey the timeline which they have set for you, right? So here, if we have to apply the same thing in a country, for a society, the society needs certain rules, certain regulations which are going to help to bring about order and discipline. That is law. So it is a set of rules and regulations which are framed by a higher authority, that is the state. And what is it for? To control and regulate relations. Relations between whom? Relations between persons and the state. To bring about order, discipline, security, stability in the society. And what will happen if you don't obey the law? Yes, failure to comply will result in some kind of a penalty or some kind of a punishment. So there you have a very simple meaning of law. Rules, regulations set by a superior or some higher authority. And what is it needed for? Stability, security, correct? Now just understand, in business, when somebody wants to start a business or wants to enter into commercial transaction of some kind, doesn't he need to know certain rules, regulations? Isn't it? Yes, he has to know about it. He needs to know that if something goes wrong in this business transaction, can I take the help of the law? What does the law have to say in this? He needs to know about this, right? So, importance of law is very, very necessary, and each one of us needs to understand it. Now let's understand the classification of law. So you've understood the basic meaning. Now let's understand the classification of law. Broadly speaking, okay, law can be classified into public law and private or civil law. Now, what do we understand or study under public law? Okay? Public law governs the relations between individuals and the government, and those relations between individuals which are of direct concern to the society. That means if something goes wrong, the individual can directly approach the state. Okay? What is private or civil law? It governs the relationships between private individuals. Private individuals, for example, if I go to a shop to buy something, I pay the shopkeeper the money, but he refuses to sell those goods to me. Refuses to sell means first he has agreed to sell the goods to me, and now he is refusing to give me the delivery of those goods. Now, that means something is wrong. I've already paid him, but he's refusing to give my goods to me. So what he's doing is wrong. Can I approach the law and get help? Yes. So in this case, I, individual, is seeking protection from the law, with the help of the law, from another person who has caused me some loss. So it is between individuals, right? Now, public law is again divided into which are the main types of public law. You have the constitutional law, you have the administrative law, criminal law, and international law. And under private law, you have law of contracts, which we are going to study in detail. We have the law of torts, we have family law, and we have succession law. These are just a few of them. Okay? To understand law, we need some kind of a base. So first, let's understand the law of contracts. Now, the law of contracts lays down the rules and regulations relating to making, performance, and discharge of various types of contracts, including the contract of sale, including the contract of partnership, and various others also. The law of torts. Now, what is a tort? tort is a civil wrong, okay? And tort law is different from criminal law. Torts may result from negligent as well as international or criminal actions, and tort lawsuits have lower burden of proof. Now, actually, this is not part of our current syllabus, but it is just for information. Then you have family laws, which deals with legal issues that arise in families and other personal relationships, such as marriage, divorce, adoption, maintenance, guardianship. And you have the law of succession, where the law lays down a uniform and comprehensive system of inheritance and succession. Okay? Then under public law, you have constitutional law, which lays down the foundation of the state and postulates the supremacy of law in the functioning of the state. It sets out the form of the government, how its different branches work, and describes the basic rights which are given to the citizens. As you all know, we have the Constitution of India, correct? Now, in the Constitution, we have certain rights. We have certain duties which are given to us by the Constitution itself. Correct? So if something goes wrong, if the state denies us our freedoms, can we approach the state and seek remedy from the state? The answer is yes, because this is constitutional law is a part of public law. And as I stated earlier, public law governs the relations between the individual and the state. Then you have administrative law. Now, what is administrative law doing? Administrative law refers to the body of law which regulates bureaucratic managerial procedures and defines the powers of administrative agencies. They are enforced by the executive branch of the government. That is, see, our government is divided into three, right? The legislature, the bureaucracy, and the judiciary, right? So administrative law is basically of the bureaucracy. That is the law part of the administrative law. Then you have criminal law, which involves the state imposing sanctions for defined crimes committed by individuals or businesses in order to achieve justice and social order. Criminal law in India comes under the IPC, which most of you may have heard of. IPC meaning the Indian Penal Code. Then you have the international law. Now, what is the international law talking about? This governs the international relations between nations, their various treaties and pacts which are entered into. Let's just now understand the classification of law under the, that is, let's understand about the public law. Under public law, first we have the constitutional law. Now, as you all know, we have India's constitution, right? Now, the constitution has given each and every citizen of this country certain rights, certain privileges, certain duties as well, correct? So, constitutional law lays down the foundations of the state and postulates the supremacy of the law in the functioning of the state. It sets out the form of the government, how its different branches work. It describes the basic rights given to the citizens. Then we have the administrative law. Administrative law refers to the body of law which regulates bureaucratic managerial procedures and defines the power of the administrative agencies. Administrative agencies, the bureaucracy, correct? They are enforced by the executive branch of the government. Now, as you all know, we have three branches of our government: the legislature, the law making organ of the government; the executive, the law implementing organ of the government; and the judiciary, which is the law protecting organ of the government. So administrative law, as we see over here, they are enforced by the executive branch of the government. Then you have criminal law, which is very commonly in India known as the IPC, Indian Penal Code. It involves the state imposing sanctions for defined crimes committed by individuals or businesses in order to achieve just and social order in the society. And then we have international law. Now, as you all know, different countries of the world need to have relations of peace with each other, need to have friendly relations with each other. There are n number of international disputes. How are they to be resolved in peaceful manners? Through negotiations, through discussions, correct? So we have international law, which governs the international relations between nations, their various treaties and pacts, how they are formed in order to maintain international peace and security. Now let's understand what is the meaning of mercantile law. Now, first of all, which category does our mercantile law lie in? Is it part of the public law or private law? Well, it is part of the civil law, okay? It deals with the rights and obligations which are arising out of mercantile transaction in respect of mercantile property. Let's understand what this means. First of all, did you understand that it is a part of civil law, it is a part of private law, and not a part of public law? Because it is governing the relations between individuals, not necessarily the relations between individual and the state, correct? Then it deals with the rights and obligations. Rights, what are my rights? What are my obligations, correct? Then, arising out of mercantile transactions. What are mercantile transactions? Mercantile transactions. Mercantile means related to merchants, correct? So, transactions which merchants are involved in. Business transactions, commercial transactions, trade transactions. The rules and regulations relating to these transactions are contained in mercantile laws. Arising out of mercantile transaction in respect of mercantile property. Thus, mercantile laws means a body of laws which regulate the commercial, business and industrial transactions of mercantile persons in relation of mercantile property, okay? So this is the meaning of the word. First we understood what is the meaning of law, and then we have understood what is the meaning of mercantile. So now when we put both the words together, mercantile laws means what? Mercantile laws means the set of rules and regulations made by the state for what purpose? For the purpose that these mercantile persons conduct their business mercantile transactions in a smooth, orderly manner, correct? Now, let's understand what is the meaning of the word contract. Now, understand first of all, now how did we move from mercantile laws to contract? Now, first let me give you a bit of background. Mercantile transactions, as we understood, are the transactions of mercantile persons. Now, when a businessman, when a merchant, when a trader is involved in a business commercial transaction, okay, he will be involved in making offers. He will be involved in entering into contracts. He will be involved in making payments, correct? He will be involved in entering into partnership or even formation of companies, correct? This is all that business or mercantile transactions can be involved in. So the first thing is making of contract. So all the rules and regulations relating to formation of these commercial business legal contracts are compiled together in an act which is called as the Indian Contract Act. Okay. All the rules and regulations relating to buying and selling of goods is compiled in a separate act called as the Sale of Goods Act of 1930. And then we have all the rules and regulations relating to formation of partnerships is contained in the Indian Partnership Act of 1932. Are these the only transactions which merchants are involved in? What about when they have to be involved in money transactions? What about checks? What about bills of exchange? What about promissory notes? All the rules and regulations related to these are contained in the Negotiable Instruments Act. Why? Because a check is a negotiable instrument. Don't business people form companies? Of course they do form companies. So the rules and regulations relating to formation of companies is all of those rules are compiled in a separate act called as the Companies Act. But for your syllabus at the CPT level, we will be studying the three main acts, that is the Indian Contract Act, Sale of Goods and Partnership. So we need to understand the law of contract first. What is the meaning of law of contract? Now in India, the law of contract is contained in the Indian Contract Act of 1872, and it was enacted to lay down the legal rules relating to promises, their formation, performance and enforceability. Let's say your parents, okay, they told you that when you get 85% or if you get 85% marks in your 12th standard examination, we will gift you a new mobile phone. Okay, that's what they told you. And they made a promise to you. And you told them that, yes, I'm ready to work hard as long as you fulfill your promise. And they said, yes, we are going to fulfill our promise. Okay, now a promise has been made. Now you study hard. You get 85% marks in your 12th standard exam. Your results come out. And you have got 85% marks. So you go to them and say that, see, I got 85%. Now please keep your promise and buy that mobile phone for me. And they said, yes, it's very good that you got 85% marks. Let's just wait. Let your CPT result come out, and then we will give you the mobile phone. Now what happened? They made a promise to you, but they did not keep it. Correct? Can you take some action? No. Is that a contract that you entered into? No. That is just a social or domestic promise. It is not a contract. Correct? Now let's say that you take admission in the college. In your college, you took the form of your college, you filled it, you submitted it, you paid the fees also, admission fees, you got your I-card, you got your receipt of payment, everything. Okay? Now, is this a contract which you have entered into with your college? Yes, this is a contract. And now, when you've already paid the fees and the college refuses to conduct lectures, have they broken their promise? Yes. Can you take any action against them? Yes. Why? Because this is a contract. Yes. So, like these contracts, we are going to be studying under the Indian Contract Acts. Now, can all agreements become contracts? No. All agreements cannot become contracts. Which agreements can become contracts? That entire framework has been given to us by the Indian Contract Act. Right? Now, the law of contract has certain features. Now, what are the features of the Indian Contract Act? First of all, it is not the whole law of agreements. It is concerned with only those agreements where the intention of the parties is to create legal relations. And now what first? What does this mean? Okay. Let's say you asked your friend, will you come out for a movie with me? Your friend said, yes, sure. Which movie? What time? Which theater? You tell him all the details, that the movie is at 6 o'clock at City Pride Theatre. Will you come with me? He said, yes, of course, I'm ready to come with you. You promised to come with me? Yes. He said, yes. Okay. He tells you that, okay, you go and wait there. You go there, I'll come at the appointed time. Okay. So you go there perfectly, you go 15 minutes early only, and you are waiting there. You wait, it's almost 6 o'clock. Your friend has not yet come. So you give him a call and you ask him. But he's not answering his phone. So you think, okay, fine, he must be riding the bike, so he'll reach. He's still not answered. It's 6:05. People have started going inside the theater to watch the movie, and the movie's already started by now. Your friend has not yet come. You try ringing him up again, but he's still not answering the phone. You have no option but to wait for him because his ticket is with you. Correct? So you wait outside the theater. Now, it's almost half an hour that you have waited, and there is no sign of your friend. Now, when you made this offer to him, will you come with me for a movie? He said yes. He accepted your offer. But he did not keep it. Means he did not keep his promise because he did not come for the movie. And your tickets got wasted. Right? Because even you didn't feel like watching the movie alone. So even you go off. Right? Now here, is this a contract? No. This is not a contract. Why? Because this is a social agreement. It is a domestic agreement. Okay? It is a casual agreement. Here, if something goes wrong, the intention of both you as well as your friend is not to create a legal relation. Only where the intention of both the parties is to create a legal relation, only those agreements become contracts. So what this is stating is that it is not the whole law of agreements. It is not concerned with those agreements where the intention of the parties is not to create legal relation. Now, the general presumption meaning assumption, the general assumption is that in case of commercial or business transactions, intention of parties is to create legal relations, unlike social and domestic agreements. Meaning what? The law states, the law presumes, that is the law assumes that if you are entering into a commercial transaction, into a business transaction, your intention is to create a legal relation. And if something goes wrong, then can you approach the law for help? Yes, because your intention is to create legal relation. And only those agreements become contracts, not social promises. Like for example, your father invites a family friend over for dinner. They say, yes, we will come, and then you've made all the preparation at home. Okay, everything has been arranged, the food has been prepared, the table has been laid, everything is perfect. And now, just a half an hour before, they call up and say, sorry, we cannot come because of certain emergency. Now, what happened? First of all, can you take some action against them? No, because this is a social promise. This is not a commercial transaction. Okay? Then you have, it is not the whole law of obligations. Obligations meaning duties, meaning responsibilities. It is not the whole law of obligations. It is concerned with those obligations or responsibilities which arise out of a contract, that is contractual obligations, and not social, religious or moral obligations of the people. See, when it's a commercial or business transaction, people enter into the agreement. Right? Intention is to create legal relations. So when you enter into a contract, you have certain responsibilities, certain obligations, certain duties which you are supposed to perform. You have rights as well as duties. Now, it is your right to, both the parties have rights and obligations. You have a right to demand performance from the other party. The other party has a right to demand performance from you. Similarly, you have an obligation to perform your promise under the contract. Similarly, the other party also has a responsibility to perform his promise under the contract. So whatever promises parties have made under the contract are called as their obligations, their duties, which they have to perform. Let's take an example. You go to a shop to buy a pen. Fine, you go to the shop to buy a pen. Now here, first of all, is this going to be a social transaction that you're going to pay a social visit to the shopkeeper? No. Is it going to be a commercial transaction, going to the shop to buy a pen? Yes, it is a commercial transaction. Now here you are to one side the buyer and to the other side is the seller. So you are two parties, okay, over here. And this is a commercial transaction. Now, what does the law say? That in case, here we have it, the general presumption is that in case of commercial or business transactions, intention of parties is to create legal relations. So your intention is to create a legal relations, right? So you go to the shopkeeper and you make him an offer, that is you ask him, is he ready to sell a pen to you? And you give the specifications of what kind of a pen you need from him, okay? Now if he has that kind of a pen, he will say, yes, I do have it and I am ready to sell that pen to you. So he gives the pen to you to examine, to see, to verify, to just satisfy yourself that this is the kind of pen you need. So you'll check it out, you'll examine it, you'll try it, right? You'll do all this, and when you are satisfied that yes, this is the pen that I want, then you ask him the price. He tells you the price. There's exchange of money over here. So he tells you the price also. Then you tell him, yes, I'm ready to buy it, correct? So now what has happened? A contract has been entered into. There are two parties. It is a commercial or business transaction. There are goods over here, right? Now, here, both of you, the buyer as well as the seller, both have certain rights and certain duties or obligations or responsibilities. Okay. Now, what is your right? Your right is that you are going to get the pen from him. But to enjoy that right, what is going to be your contractual obligation? Your contractual obligation is to pay him the money, right? Now, the shopkeeper, the other party, he also has rights and duties under the contract. Yes. What is his duty under the contract? His duty is to give you the pen, to sell that pen to you. And what is his right? His right is that he has to demand the payment of that pen from you, right? So both the parties have rights and duties or obligations. Now these obligations come under which? Under what rather? They come under the contract. So the Contract Act is concerned only with this particular transaction of yours over here, contractual duties. So you pay him the money and he gives you the pen, right? Your contract is over with him. Now, how you use that pen, or whether you use it for yourself or you gift it to somebody else, has any of that got to do anything with the contract? No. So that is, Contract Act will not decide whom you gift it to, how you use it, how many hours you write with that pen. No. It is concerned only with your right and your duty under that particular contract. Okay. Then you have, it only lays down the legal framework within which contracts can be entered into by the parties. That means what? Contract Act will give you the framework, that these are the rules, these are the regulations. Who can enter into contract, who cannot enter into contract, correct? Once a contract has been entered into, how should it be performed, right? If the contract is not performed, then and a breach is committed. Breach means breaking of the promise of under the contract. So if a breach is committed, that means someone fails to do what they promised to do under the contract. What action can be taken? All this, that is the general framework of making of a contract. This is given to us by the Contract Act, right? Actual terms and conditions of the contract, who decides? Parties themselves decide. Contract Act is not telling you what terms you should enter the contract, what should be the conditions. No. It is just giving you who can enter contract, how should it be entered, how should it be performed, what will happen if you don't perform, and how is it discharged, means how is the contract over. Let's take an example. Like the same thing, you go to the shopkeeper to buy a pen, right? Now, Contract Act will not tell you which specific pen you should buy, or what specific goods or which specific types of pens the shopkeeper can sell you, what is going to be the price of that, how is he going to deliver it to you. No, That who decides? Parties themselves decide. Okay, we said that when you take admission in a college or in any institute, educational institute, have you entered into a contract? Yes, you have entered into a contract. The Contract Act, does it tell you which college to go to? No. Does it, the Contract Act, tell the college how much fees to charge? No. So who decides all that? The parties decide, not the Contract Act. Okay, so that is our third point, that the terms and conditions of the contract are to be decided by the parties themselves, not the Contract Act. And last, you have the Contract Act creates jus in personam. Now, jus in personam is a legal maxim. It is a legal term which simply means what? It means a right against a specific person. Okay, right against a specific person. Now, we said that contract is entered into between two parties, right? Two persons, two parties. Now, if the example of the shopkeeper, when you go to buy a pen from the shopkeeper, correct? Now, you are one party, the shopkeeper is the other party. Now, if something goes wrong, you pay him the money, but he refuses to give the pen to you, or he gives the pen to you, but you refuse to pay him the money, right? Now, this contract was between two persons, that is you and him. So, if something goes wrong, who can you get it enforced against? If the shopkeeper fails to give the pen to you, you can get the contract enforced against the shopkeeper, not against a third person, no. And if you refuse to pay him, he is going to demand payment from you, not from the third person. So that is what it means. It means the Contract Act is creating a right against the other person, a specific person, not against somebody else. If two persons have entered into a contract, those two persons have rights and obligations under the contract. And if something goes wrong, only those two people can file case against each other. That is the meaning of in personam. Jus in personam, right against the other person. This means it is a right available against a specific person. When two parties enter into a contract, and if one party fails to perform his promise under the contract, then the other party can get the contract enforced against him. Correct? So when you have paid the fees and taken admission in your college, and later the college does not conduct any lectures at all, then you will get this contract enforced against that specific college, not some other college, right? That is jus in personam. Contract Act does not create jus in rem. Now, what is the meaning of jus in rem? This is a right against a thing and is available against the whole world. Indian Contract Act is concerned with jus in personam. The Sale of Goods Act is concerned with jus in rem. That is, Sale of Goods Act creates jus in rem, which is available against specific thing, not person, but things, because in sale of goods we are going to study about goods. Okay, and it is available against the whole world. That means if something goes wrong, then it is applicable against the whole world. In fact, the details of this we will do when we begin with our Sale of Goods Act. So these are the features of Indian Contract Act. Moving further, let's understand what are the sources of law of contract in India. What are the sources? So let's understand first. The Indian means what have the Indian Contract Act has a base in what? Has been formed on the basis of what? What all have contributed to formation of the Indian Contract Act? First, you have the English Mercantile Law. We have borrowed a lot from the English Mercantile Law. English Mercantile Law provides the base of the Indian Mercantile Law. Now, why is this so? Why did we borrow from the English Mercantile Law and not others? Because at that point of time, we were ruled by the Britishers. Understand, Indian Contract Act is 1872. 1872, India was under the British rule. Correct? So, we have borrowed a lot from the English Mercantile Law. Then you have statutes. Now, what are statutes? Statutes means acts, means legislation. So, when you say Indian Contract What is that? That is statutory law. Means it has been made by or framed and passed in the Parliament. It is codified. It is written. So it has become an act. So whenever you have the word or you come across the word statutory law or act, it means that it has been codified, it has been written down. Okay? So these are acts or legislations passed by the Parliament and signed by the President. Then you have judicial precedents. What are judicial precedents? Judicial precedents means basically judge-made laws, which are based on past judicial decisions. Means what? That see, wherever a case is being tried in the court of law, it may happen that over there that relating to that particular case, the judge has passed a judgment which later becomes the basis of a law itself. So these are called as judge-made laws, which are forming the base of a new law. Now, if this kind of a judicial precedent is passed by a judge of the Supreme Court, then that decision becomes binding on all the lower courts. As you know, in our Indian judiciary, at the apex, that is right at the top, is the Supreme Court. Below the Supreme Court are all the higher courts, high courts that is. And then you have the district courts, correct? So the judicial precedents passed by the Supreme Court are binding on the high courts. Judicial precedents, the judgments passed by the high courts are binding on the district court, correct? So you have that hierarchy over here. So you have judicial precedents or past judicial decisions which can become the base of law itself. Then we have customs, usages. Customs and usages are those which have been practiced from a long, long time, generations and generations and decades and decades. There are some practices related to commercial or business transactions which have been used widely, which are legal, okay, which are certain, and which are not against any existing law of the land. Then those customs or usages can also be turned into law. So we have base of Contract Act coming from these certain usages, certain practices which have been which have provided our base. They have to be widely known, but for a usage or practice to become a law, it has to be widely known, known to all. Okay? It has to be certain. It cannot be ambiguous. It cannot be uncertain or vague. It has to be absolutely certain. It has to be reasonable, and it should not be opposed to any legislative enactment. Means whatever the custom, practice or usage is, by implementing it or by practicing it, you should not be going against any legal enactment or any legislative enactment or codified law or written law. And then we have justice, equity and good conscience. Now, what is justice, equity and good conscience? In case of absence or silence or ambiguity, ambiguity meaning little bit of uncertainty, cases can be decided on the basis of justice, equity and good conscience. What is if in case the law is silent on some part or there is a slight uncertainty in its interpretation? Then how should the cases be decided? The cases are decided then on the basis of justice, equity and good conscience, meaning what is just has to be done. Okay? So these 5 are the sources of the law of contract in India. Now, justice, equity, good conscience, we will be coming to that when we do a special types of contracts known as Quasi Contracts, which is indeed a part of your syllabus itself. We'll be covering this in detail when we do Quasi Contracts. Now let's understand about the Indian Contract Act. So, see, we began with understanding the meaning of law, then understanding the meaning of mercantile law, then the law of contract in India, and now we begin with Actual Contract Act of 1872. Now, every act which we have has certain common features, okay? Every act will have a preamble. See, our constitution has a preamble, which you all are aware of. Similarly, Indian Contract Act is going to have a preamble. The Sale of Goods Act has a preamble. The Partnership Act, Negotiable Instrument Act, Companies Act, all acts have certain common features, the first being the preamble. And when we say act, what do we mean by act? Act means codified written laws, okay? So, and these are the features which are common. First, they have so first is the preamble, then you have section 1. Now what all is there in section 1? Section 1 has the title. So what is the title of our act? It is the Indian Contract Act 1872. What is the date of commencement? Commencement means when it was implemented. The date is 1st September 1872. What is its extent? Extent means the geographical boundaries where this law is applicable to. This act is applicable to the whole of India except the state of Jammu and Kashmir. Now, why not Jammu and Kashmir? Because our constitution, Article 370 of our constitution itself has given a special status to the state of Jammu and Kashmir. Therefore, most of these acts are applicable to the whole of India except the state of Jammu and Kashmir. So, does it mean that there are no contracts entered into in the state of Jammu and Kashmir? No. But the laws relating to formation of contracts are made by the state government, okay, in consultation with the center. Then we have the scope. Scope means who is this act applicable to. First you understood in extent, you understood the geographical boundaries, correct? Now you need to understand who is it applicable to. So it lays down the general principles of contract law, and it is not a complete or exhaustive one. It is not a complete or exhaustive one means that there are various other types of contract also which are not contained in the Contract Act. Okay, which means for example, insurance contract. Now, insurance contract, when you enter into an insurance agreement, correct, with an insurance company, is that a contract? Yes, it is a contract. But is it covered under the Indian Contract Act? No, it is not covered under the Indian Contract Act, but it is still a contract. Yes, that is what is the meaning of this last sentence, that it is not a complete or exhaustive act. Why? Because there are many other types of contracts which are not covered under the Indian Contract Act. Okay. Now, Indian Contract Act, who is it applicable to? It is applicable to persons. Yes. Persons means whom? In law, persons means natural persons as well as artificial persons. Natural persons are whom? Natural persons means human beings. So, is the Contract Act applicable to human beings? Yes, because they are natural person. And what about artificial person? Artificial person means legal entity. That means which does not have a natural existence, but which is artificially created by man. So you can have corporations, you can have companies which are also regarded as persons. So is the Contract Act applicable to these also? Yes. So when we say persons, we mean natural, human beings, as well as artificial, that is legal entities. Okay. Then let's understand about the meaning of contract. We understood now. See, as I told you that every act has certain common features. First is the preamble, then there is section 1. Section 1 we understood, which has the title, the date of commencement, the extent and the scope, that is given in section 1. Now section 2 onwards begin the definitions and the interpretations of those topics or those words itself, the terms itself. Now our title is Indian Contract Act. So first let's begin with the definition and understanding of the word contract. What is the meaning of contract according to the Indian Contract Act itself? As I told you, from section 2 begin the definition and interpretation, correct? So we have section 2H, which is giving us the definition of contract. And what is it? A contract is an agreement which is enforceable by law. Enforceable by law means what? We'll understand that in detail. So first let's understand how a contract is made. So you have contract. Contract means agreement. The word agreement is there in a definition itself. So agreement plus legal enforceability. Legal enforceability means which can be enforced by the law. What can be enforced by the law? Or when can the agreement be enforceable by law? When the intention of the parties is to create legal relations. And where is there a presumption by law or assumption by law that intention of parties is to create legal relationship? In the case of commercial or business transaction. Correct. Right? So agreement plus legal enforceability is a contract. But what is an agreement? Agreement means a promise plus consideration. What is a promise? Promise means a proposal plus acceptance. What is consideration? Consideration means something in return. Now, all these definitions which you see over, all these terms which you see over here, we are going to understand each and every one of them in detail, because this, now see, contract, we began with the word contract, is made up of two: agreement plus legal enforceability. Agreement means what? Promise plus consideration. Promise means what? Proposal plus acceptance, right? So we need to understand all these terms and then come back to the word contract, because the base is lying in the word proposal or offer, okay? Now, let's understand the definitions as per the sections of the Indian Contract Act. First you had contract, meaning agreement enforceable by law. Now what is an agreement? According to section 2E, agreement means every promise and every set of promises forming consideration for each other. We'll understand the details. Consideration according to section 2D means what? When at the desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or abstain from doing something, such act, abstinence or promise is called as a consideration for the promise. Now, in this definition we use the word promise. What is the meaning of promise? Section 2B tells us what is a promise. When a person to whom a proposal is made signifies his assent thereto. Assent means acceptance thereto. Proposal is said to be accepted. Proposal when accepted becomes a promise. In this definition you have the word proposal. Okay. Now what is the meaning of the word proposal? What is the meaning of the word proposal now? When one person signifies to another his willingness to do or abstain from doing anything with a view to obtaining the assent of that other to such an act or abstinence, he is said to make a proposal. Legal language appears a little confusing. It just appears, but it is not at all confusing. It is very easy to understand. Let's just analyze each word and go about it a little slowly, okay? Now, the base is proposal. So let's first go and let's understand the meaning of the word proposal or offer. Many times you'll hear the word proposal, many times you'll hear the word offer being used. Are they two different things? No, only the word is different, meaning is the same. Under the Indian Contract Act, we use the word proposal. Under the English law, we use the word offer. Can we use it interchangeably? Yes, no problem at all, okay? Now, first let's understand what is an offer or a proposal. When one person signifies to another his willingness to do or not to do something, okay? So, when one person means the person who is making an offer or proposal is called as offerer or proposer. Now let's say I want to make an offer to you. I will be called as the offerer or proposer. And who am I making the offer to? To you. So you will be regarded as the offeree or proposee. So I make an offer to you. Are you ready to attend these virtual classroom lectures? I make an offer to you. Are you ready? And you say, yes. Okay? So I am making an offer to you. Are you ready to attend these virtual lectures of us? Okay? I made this offer to you. Now, when I make this offer to you, do I have some kind of an intention in my mind? Do I want you to say yes, or do I want you to say no? Obviously, no, I want you to say yes. That's why I'm making the offer to you in the first place. So, when one person signifies, communicates to the other his willingness to do something. Willingness to do something means I'm telling you that I'm ready to take your virtual classes. Are you ready to attend the virtual classes? Correct? I'm making an offer to you because I'm ready to do something. I'm ready to do something means an act. Okay? Or not to do something or abstain from doing anything. Or I tell you that, see, I offer not to do something. Like for example, you've heard a number of times how a newcomer in the film industry, the producer makes an offer to the new actor that, see, till our film is complete, you will not act in any other films. Till this film is made and released. Till that time, you will not enter into any other acting contract with any other studio or any other producer. Now, is this also an offer? This is an offer not to do something. But is it still an offer? A valid offer? Legal offer? Yes. So, offer is not just to do something. Offer can also be not to do something. Okay? So, it can, when I have made a proposal or offer to do something, it is called as act. When you have made an offer or proposal not to do something, it is called as abstinence. So, when one person signifies or communicates to the other his willingness to do means act, or abstain, not to do something or anything, with what view is he making this offer? To obtain the assent, to obtain the acceptance of the other person to such an act or abstinence, he is said to make a proposal. So when I make an offer to you, are you ready to attend these virtual classes? I am making an offer to you to do something. What? To attend the classes. I am making this offer to you with what intention? So that you say yes. Correct? Now, when a film producer makes an offer to a newcomer that I am ready to take you in my film, provided you do not act in any other film till this film is ready and released. He is making an offer to the newcomer not to do something, abstain from doing something. Now he is making this offer with what intention? So that the newcomer says yes, correct? So this is called as, when this offer is made to the other person, it is called as a proposal or offer, correct? Now when the other person accepts this offer, then the offer becomes a promise. So when I make that offer to you of virtual class, you accepted my offer. Now this offer has been converted into a promise when you gave your acceptance. Okay? So that is promise. Section 2b. What does it say again? When a person to whom the proposal is made, so I made the proposal to you, okay, and you signify your assent. Assent means acceptance. When you signify your acceptance to my proposal, then the proposal is said to be accepted. And a proposal, when accepted, now it has become a promise. So first, when I made the proposal to you, I was the proposer. To whom it was made? To you. So you were the proposee. Now, when you accepted this, it has become a promise, correct? Proposal has now become a promise. So the proposer means me, I have become the promisor, and you have become the promisee. Why? Because proposal became a promise, correct? So that is a promise. Now, what is consideration? Now see, I made a promise. Now, the promise is made, correct? When you gave your acceptance, proposal has become a promise. Now, my proposal in the first place was what? That are you ready to join these virtual classes? And you gave your acceptance saying yes, okay? Now, I made the offer, you gave acceptance. But in return for the promise which I have made, I'm going to get something in return from you. And in return for the promise which you made me, you are going to get something in return, right? So, let's say that I am going to now be giving you admission to virtual class. That's my part of the promise. In return for that promise, I am going to get fees from you, right? So whatever I get in return for my promise is called as consideration. So for giving you admission in the virtual classes, in return as consideration, I'm going to get fees, correct? This is on my part. Now on your part also, when you are making a promise, you should get something in return, correct? So you have made the promise to pay the fees to me. And in return, what are you going to get? Admission in the virtual class. So here both the parties, you and me, are both the parties over here. It is a business or commercial transaction. So can this agreement become a contract? Yes, because the law presumes that in case of business or commercial transactions, it becomes a contract, right? Intention is to create a legal relation. And here both the parties are getting something in return. That is consideration. So this is the actual definition of consideration, which we are going to go into detail, where we have the entire topic of consideration. Now it is enough for you to understand that consideration means something in return. Okay? Then what is an agreement? Agreement means every promise. Now I made the promise to you, you made a promise to me, correct? Every promise and every set of promises are forming consideration. For my promise which I gave you, I am getting consideration, yes. For the promise which you made to me, you are getting consideration, yes. So, both our promises have consideration for each other, yes. Now, when the promise is having consideration, those promises are going to become agreements. That is the definition of agreement. So first it was an offer or proposal. When acceptance was given to it, it became a promise. Now when for my promise, I am getting consideration, and your promise, you are getting consideration, that promise has now been made into an agreement. Correct? So it has reached the stage of an agreement. Now, are all agreements contracts? And are all contracts agreements? Understand this. Now, let's go to an earlier example which we had. You make an offer to your friend. Will you come with me for a movie today at 6 o'clock in the evening at this particular theater? You made an offer to him. With what intention are you making an offer? So that he says yes. Okay. So he gave you his acceptance. Correct? Now when he accepted, your offer now has become what? Your offer has now become a promise, correct? Because it got acceptance. Now, that promise, can it become an agreement? When will a promise become an agreement? When the promise will have consideration. And both of us, both the parties are making promises to each other. So both the parties should have something in return. So you made in return for your promise of taking him out you are going to take him out for the movie, and he has also said yes to it. So there are promises made, and there is something in return for both of you in this entire process. But, so agreement is there, but is this agreement going to become a contract? Why? Because only those agreements will become contracts which have legal enforceability. That is our definition of contract. And which agreements can become contracts? Only those which have legal relations, or intention is to create legal relations. And when is there a intention to create legal relations? Only when what did we say about presumption? The presumption of law is that only where the intention is to, in the case of commercial or business transactions, intention of parties is to create legal relations, okay, subject to contract. Fine. So here between you and your friend, when you are inviting your friend for a movie, is this a commercial or business transaction in the first place? No, it is a social domestic promise, correct? So can this kind of an agreement, though acceptance has been given, can it become a legally binding contract? No. Correct? So why? It is not a business or commercial transaction in the first place. Correct? So first, to understand the meaning of contract, we have to first understand what is the meaning of proposal or offer. In our later lectures, we will be understanding in detail about all of these. What is a proposal? What is acceptance? What is a promise? What is consideration? All this, okay? And then ultimately it leads to the formation of contracts. So again, I repeat my question. Are all agreements contracts? What is your answer going to be? No. All agreements are not contracts. Then which agreements turn into contracts? Only those agreements which are enforceable by law. And which agreements can be enforceable by law? Those we are going to understand under section 10. Okay? Now, moving on further, let's understand this. Which agreements can become contracts? So, essential elements of a valid contract. Now, as I told you that from section 2 onwards, we have all the definitions, requirements and interpretations given to us by the Indian Contract Act. So now in section 10, we have all the essential elements of a valid contract. Means which agreements can become contracts, we are going to understand over here. As per section 10 of the Indian Contract Act, all agreements are contracts subject to what? If, understand, let's. Here. So you have contract in the middle. When will an agreement become a contract? First, when there is valid offer and acceptance. See, in the earlier slide we have seen how the base is offer or proposal. You have to make a legal and valid offer in the first place. Then acceptance needs to be given, correct? Without that there will be no contract itself. So first there has to be a valid offer and acceptance. Then this offer and acceptance has to be made by, so that means contract can be entered into only by competent parties. Then it is done with the free consent. Contract is entered into by free consent. It should have legal object and consideration. And lastly, it should not be expressly declared as void. This is just kind of an introduction. Now let's go into the details of essential elements of a valid contract. First one was offer and acceptance. Offer made by one person to another must be legal and valid in a prescribed mode and manner. Now, who has given us this framework? What is a legal offer? Whether it is legal or no? What should be the mode, manner? What this framework has been given to us by the Indian Contract Act. So, when one person is making an offer to the other person, okay, with the intention to get his acceptance to it, that offer or proposal has to be a legal and valid offer. It has to be done in a proper manner. It has to be done through a proper mode. What is this manner? What is this mode? Which offer is legal? How it should be made? How it should be communicated? We have to do this in detail. Okay? Then the second is which we will further study in our next lectures. Now the person who is making the offer or proposal is called as the proposer or the offerer. The person to whom the proposal or offer is made is called as the proposee or offeree. For example, you have the proposer or offerer making an offer. Are you willing to sell your Sony Vaio laptop to me for 15,000 rupees? Now here, first of all, is it a legal valid offer? Is it legal? Do you have the legal permission to sell laptops? Yes, you have. Okay. So here and the amount. How much to sell it for? Is the Contract Act going to tell you the amount? No. Who is deciding it? Offerer himself is going to decide that, correct? So he is making a legal and valid offer. Is the offer made in clear terms? Now here, if the offerer would have said, are you willing to sell your Sony Vaio laptop to me for any price you want? Any price you want? Is it certain? Is it specific? No, it's not clear. So that is not a valid offer. Or offerer says to the offeree, are you ready to sell me any laptop you want? Any laptop you want? Vague, not clear. Offer is not clear. So it is not a valid offer itself. So when you are making your offer, it has to be done in a clear manner. It has to be in a definite manner. It cannot be vague, correct? Now, so he is making an offer to the offeree or the proposee. Now what is the answer going to be? Proposee says, yes, sure, I accept your offer, thank you. He has accepted this offer. Has he communicated this acceptance? Yes, he's already communicated this acceptance. Yes. So now when the acceptance is given, this proposal or offer has become what? It has become a promise. Correct? Now, this promise, when will it turn into an agreement? Promise becomes an agreement when there is something in return for both the parties. Correct? Only then it becomes a agreement. So here, when offerer, that now he has become the promiser, correct? Because it has become a promise. For his promise to buy see here he is ready to buy the laptop for 15,000. So when he gives his money of 15,000 rupees, is he going to get anything in return for that money which he is giving? Yes. What is it going to be? Laptop. And the promisee, okay, who has accepted the proposal, here he is going to be selling his laptop. Yes. What is he going to get in return as consideration? He is going to get money. So both the parties are giving something and getting something in return. Yes. So what is that? Now that has become an agreement. Correct? Now is this agreement going to transform into a contract? What do you think? Tell me. Yes, you're right. It is going to become a contract. Why? It is going to become a contract because this is a commercial or business transaction. And the legal presumption is that in case of commercial or business transactions, intention of the parties is to create a legal relations. So, this is going to become a contract. Again, subject to conditions. Okay. So, first, basic essential element of a valid contract is valid offer and acceptance of the offer. Then let's understand the second important element, and that is legal relations, which we already touched upon earlier. Only those agreements become contracts where the intention of the parties is to create legal relations. Social or domestic promises do not become contracts, correct? There is a general presumption that in case of commercial or business transactions, intention is to create legal relations and hence legal enforceability. So in the example, earlier example, commercial business transaction, intention is to create legal relations, so that agreement does become a contract. Then, thirdly, competent parties. The law says that if you want to enter into a contract, both the parties have to be competent enough. Competent according to whom? Competent means capable. They have to be capable of entering into the contract. Who decides their competency or capability? Not the parties, but the law. See, as I told you, law is giving the framework. Who can enter into a contract? Parties who are competent enough. So, persons who enter into a contract should be competent to contracts. The following are considered as incompetent and hence cannot enter into a valid legal contract. Who are incompetent? Minor, person of unsound mind, and persons who are disqualified from contracting by law itself. Okay? So these three categories the law says cannot enter into contracts. Okay? First, who is a minor? Minor who is not of the age of majority as per the law to which he is subject. Age of majority of a person is not given by the Indian Contract Act. The Indian Majority Act has given us the age of majority to be 18 years. In majority of the cases, it is going to be 18 years. Okay? And under exceptional cases, it is going to be considered as 21 years of majority. We will be studying in detail further. Then who is a person who is of unsound mind? Person of unsound mind is one who is not capable of understanding the terms of the contract or form a rational judgment as to the impact of the contract on his interest itself. Who is a person of unsound mind? See, anyone who he does not have the mental capacity to understand the terms of the contract. Person who cannot form a rational, practical judgment as to how that contract or its terms are going to have an impact on his interest. He cannot understand because he is mentally not fit to understand. So according to the law, who are such persons who are considered of unsound mind? People. So the law has given us certain categories of people. First of all, the law says that a person who is considered as an idiot. Okay, now idiot in the terms of law, in the eyes of law, is a person whose mental capacity has been permanently challenged. So from birth, because of certain defects, that person cannot understand things. Okay, it is a defect from birth itself. Now, from birth itself, if you have a mental handicap, will you ever be able to enter into a contract? No. So these people are completely debarred from entering into contracts, because in fact the law is protecting them. The law is saying that they on their own cannot form a rational judgment. They on their own do not have the mental capacity to understand the terms of the contract. So nobody should cheat them. Correct? Nobody should take undue advantage of this condition of theirs. So the law says it is better we do not allow them to enter into contracts. Second category is that of lunatics. Now lunatics, it is not a permanent conditions. Means lunatics are those people who may have certain time intervals where they are completely of sound mind. They can understand everything. And there are certain intervals during which they are of unsound mind. Okay? So the law says of such people that when they are of sound mind, only during those time intervals they can contract. But when those time intervals when they are of unsound mind, they cannot contract. Correct? Third category is those people who are intoxicated or under the influence of drugs, who are under the influence of alcohol, people who are under the influence of very, very heavy medicines, because of which they cannot understand. They are in a dazed situation, either under the influence of alcohol, drugs, or even very strong antibiotics or medicines where they cannot think clearly. So they are not permanently debarred from contracting. Okay, the law says that when they are under the influence of drugs, alcohol or heavy medication, only during that time they are considered of unsound mind and therefore cannot enter into contract. When they are absolutely normal and of sound mind, yes, they can enter into contracts. Okay. And of course, in this unsound mind, the law is also including the category of those people who are under the influence of hypnotism, because that time they cannot think properly, correct? They are under the influence of somebody else. So the law says that at such period of time, they are regarded as unsound mind. And you have third category is people who are disqualified by law itself from contracting. The law says that there are certain people who it is better if they don't enter only into contracts. Now, which are these people? They are like alien enemy. Now, who is an alien enemy? First of all, who is an alien? No, don't worry, it is not someone who is an extra territorial being or something. Alien in law means a person who is not a citizen of your country, of your nationality. He will be considered as an alien. Okay. Now, for example, let's say that an American citizen. Correct? Now, he is a citizen of America. He is not a citizen of India. Right? He is not an Indian. He is an American. Okay? Now, he will be considered as an alien in the terms of law. Now, here today, India and America do have peaceful relations with each other. Yes? So, during times of peace, you and he together will be considered as alien friends. So, he is your alien friend. But if there is a war declared between the two countries, now during the time of war, he will be considered as an alien enemy. So the law says that if he is your alien enemy, you cannot enter into a contract with him at this point. Correct? So alien enemies, you cannot enter into contract with alien enemy. They are disqualified from entering into contracts. Convicts. Convicts are those whose crime has been proved and who are serving a sentence in the prison. So they are behind the bars, correct? So they cannot be qualified to enter into contracts. Then insolvents are disqualified from contracting. You have foreign sovereigns or national. Now, foreign sovereigns or national, why have they been disqualified from contracting? The law says that in case something goes wrong, okay, and they do not fulfill their promise under the contract, they do not fulfill their contractual obligations, when you have to file a case against them, special permission from the center is required. And that entire process is very complicated because they have immunity from their country. Okay, their foreign immunity. It's very difficult to get contract enforced against them. So the law says better don't enter into contracts with these people. So, other than this, these are the people, three categories who are regarded as incompetent to contract by the law itself. Then you have the next important element, free consent. See, when parties are entering into the contract, the law says that they should do so freely. They should not be forced to enter into a contract. Okay? There has to be consent. Consent means what? Consent means total agreement. Consent means consensus ad idem. Consensus ad idem means agreeing upon the same thing in the same sense. And when can you agree upon the same thing in the same sense? When you have understood all the terms of the agreement in a proper manner. So the law says you need to understand all the terms of the agreement. Plus, when you give your acceptance or consent, it has to be given freely. No one should force you into entering into the contract. So, persons entering into contract must agree upon the same thing in the same sense, and their consent must be freely given and not forced. Consent is not free when it is caused by coercion, undue influence, fraud, misrepresentation. Okay, so when is a consent not free? When I have been physically forced to enter into a contract. I have not done it on my free will. You forced me, you threatened me to enter into a contract, and I entered into a contract. Yes, contract was entered into, but my consent was not freely given. Correct? So I have been physically coerced into entering into the contract. Okay, so that is a void, that becomes a voidable contract, which I can later avoid because my consent was not freely given. Then you have undue influence. When you put mental pressure, coercion means use of physical force or pressure. Now, undue influence means you used mental pressure on me. You influenced me in such a way that I said, yes, I agreed to entering into a contract with you. So we have free consent. Our next element is free consent. Free consent meaning the persons, now when you are entering into a contract, you have to do it at your own free will. Correct? After understanding the terms, conditions, everything is okay. You have to then say yes willingly. Nobody should force you into entering into a contract. Okay? So when you give consent or acceptance, it has to be freely given. That is the meaning of free consent. And when is consent not free? When somebody forced you. Okay? So when consent is said, consent is not free when it is caused by coercion. Coercion means I didn't want to enter into a contract. You physically forced me. You threatened me that if I do not enter into this contract with you, you will hurt me. You will physically beat me up. Out of fear, I entered into the contract. Okay? So the law says that this is a contract which has been entered into, but not by the free consent of the party. So this is a voidable contract. Voidable means that which can be avoided. Why? Because my consent was not free. Then the law says that contract is not induced by free consent when the consent has been caused by undue influence. Now what is the meaning of undue influence? See, when we said coercion means physical pressure or threat, undue influence means mental pressure. Okay, you mentally influenced me to such an extent that I had to say yes. I had no other option but to say yes. And why could you influence me? Because our relation was such, that is the relation between the parties is such that I am in a slightly submissive position and you are in a dominating position, and this transaction which is taking place between us, the terms of this transaction are very, very unfair terms. So when two parties whose relations are such that one is in a dominating position and the other is in a submissive position, and the terms of the contract are unfair, correct? Then the law assumes that the contract has been induced by absence of free consent, that is due to undue influence. Then you have fraud. Fraud means fraud. Fraud means cheating. I cheated you, or I made you enter into the contract by cheating you. That's fraud, correct? And misrepresentation means when I gave you false information regarding something, but it was done innocently because I myself believed that information to be true, and then I gave that information to you, but that information was false. I did not want to cheat you or fool you, but the information which I gave to you was false. On that false information, you entered into a contract with me. Now you came to know that the information is false, correct? So it comes very close to fraud. But fraud means when you're giving wrong information intentionally. You know it is wrong. Purposely you're giving that information, false information. Why? Because your intention is to cheat. That is fraud. Misrepresentation means you're giving wrong information, but you're doing it innocently. Your intention is not to cheat. Then why are you giving the wrong information? Because you yourself believe that information to be true. Like for example, you go to an art gallery. Okay? You like a painting over there. You ask the person over there, the seller, that how old is this painting? So he tells you that this painting is 60 years old by this particular painter. Okay? Now you, and the price is also very high. You agree to buy that painting only because it is 60 years old. Okay? Now the person who's selling that painting to you, he knows that the painting is not 60 years old. It's a new painting. Okay? He knows the information, but he's purposely giving you wrong information because he wants you to enter into a contract. What is this? This is fraud. Correct? Now here, take the same thing, slightly we'll change it and say, now the person who is selling the painting himself believes that the painting is 60 years old, when in reality it is not. He himself believes that the painting is 60 years old, so he tells you that the painting is 60 years old, and believing him, you buy the painting, and then you come to know that this is not 60 years old, it's a recent painting. Correct? So this is misinterpretation, comes very close to fraud. Okay? Moving ahead, next essential element is legal object and consideration. Legal object means what? Legal object means objective or purpose. What is the purpose for which I am entering into the contract? The purpose of entering into the contract has to be legal and lawful, and not something which goes against the law. So why am I entering into the contract in the first place? Is my purpose legal or not? Or my intention is to do something illegal, then it cannot become a valid contract. Correct? So our objective for entering into the contract has to be legal, and what we get in return, consideration, that also has to be legal. So A enters into a contract with B to smuggle certain goods. What is the purpose? Smuggling of goods. Is smuggling of goods legal? No. Can it ever become a contract? No, it is just an agreement. It cannot be enforceable by law, because here your purpose or objective is to do something which is unlawful or illegal. Consideration, as we have seen, means something in return. So under the contract, what you give each other is also has to be legal and valid. Okay? So legal object and consideration. Next is not expressly declared as void. Expressly means in words. Now the Indian Contract Act has, from before only, has declared certain agreements as void. Void means that which cannot be enforced by law. That means that is void, which has no existence in the eyes of law, is void. Void ab initio, void since the beginning. So whatever said and done, you can never enter into such contracts. Those agreements can never become contracts. Why? Because they expressly declared as void by the Contract Act itself. What kind of agreements are declared void by the Contract Act itself? Like, for example, those agreements which where the promise does not have anything in return as consideration itself. I make a promise to you, in return I am not getting anything. Can this become a contract? No, it cannot become a contract. There are exceptions to the case, yes, which we will later study in detail. But contracts which are made without consideration are void in the eyes of law. So that cannot become a contract. That remains just an agreement. Or for example, you have agreements where the parties decide to do something which is illegal or something which is impossible, physically, mentally impossible. It can never become a contract itself. Or those agreements which are made under mistake or even without consideration, as I said, those cannot become into contracts. So they are expressly declared as void. So we have a list of agreements, correct? So agreements made under mistake, agreements without consideration, agreements in restraint of marriage, agreements in restraint of trade, agreements in restraint of legal proceedings, wagering agreements, or which are in the form of a wager or a bet or a gamble. Those are also declared as void, not enforceable by law, by the Contract Act itself. So till here you have section 10, but there are two other important elements given under section 29 and section 56 of the Indian Contract Act, which are they. As per section 29 of the Indian Contract Act, you have certainty of meaning, which says that agreements the meaning of which is uncertain or capable of being made certain are said to be void. The terms of the agreement have to be clear, certain and specific. Only those agreements can become contract whose terms are very, very clear, whose terms are not vague, whose terms are specific in words or actions as well. Only those agreements can become contracts. So if I say that I will pay you so much amount of money if you are able to design this house as per my imagination, or I will buy this house only if it proves lucky. Now what is the definition of luck? We don't know. What is lucky for me may not be lucky for you. So lucky, is it a definite term for entering into a contract? No, it is. It's not. So such kind of an agreements can never become contracts because they are very vague. Okay. Then you have, as per section 56, possibility of performance. Only those agreements can become contracts which are possible to perform. Possible to perform means they have to be legally possible, they have to be physically possible, they have to be possible to perform itself, morally possible also. So as per section 56 of the Indian Contract Act, an agreement to do an act impossible in itself is void. If you have agreed to do some act which is impossible, like A promises B that he will get the moon down to the earth, is it actually possible to do that? No, it is not. So it is something in act which is impossible, and such kind of an agreement, can it ever become a contract? No, it cannot become a contract. So, and any agreement to do anything which is legally, physically or morally impossible to perform cannot become a contract. So we have seen what are the essential elements of a valid contract as given under section 10, section 29 and section 56. And what are they? First is there should be a valid offer and acceptance of that offer. Second, there has to be legal enforceability. Third, the parties who are entering into the contract have to be competent and capable of entering into contract. The parties who have entered into contract must do so by free consent. They should not be forced to enter into the contract. Then, parties who are entering into the contract, the object or consideration of that contract has to be legal and lawful. Okay? And they can enter into such agreements which have not been expressly declared as void by the Indian Contract Act itself. Then as per section 29, only those agreements can become contract whose meaning is clear, specific and certain. And of course, only those agreements can become contracts which as per section 56 are possible to perform, legally, physically and morally possible. Okay? So these are the essential elements of a valid contract. Now let us go to understand what are the types of contract. Okay? Now here we have two broad classifications. Classification of contracts as per the English law and as per the Indian law. Okay? Now very briefly we'll touch upon classification according to the English law. Why we need to understand this? Because as we said earlier itself, that we have borrowed a lot from the English law. Okay? So, under the English law, contracts are divided into three: simple contracts, contracts of deed and contracts of record. Simple contracts which are not necessarily formal, they may be oral or written, and they may be sealed or record not even needed. Okay? Contracts of deed are, see, deed means formal, means written, means signed and sealed. These are the formal types, deed. And then you have contracts of record, which are formal, which derives binding power from the court's authority. Okay, so according to the English law, these are the three types of contracts. Now let's understand in detail classification according to the Indian law. Okay. Under the Indian law, let's broadly classify types of contracts under three heads, that is classification as per their creation or formation, classification on the basis of their execution or performance, and classification according to validity or enforceability. First, let's classify the types of contracts on the basis of how they are formed or their creation. On the basis of creation or formation, contracts are classified into express contracts. First, express means made in words. Now, made in words means these contracts are made using words. Now, as you know, words can be spoken or words can be in the written form, correct? So these contracts can be oral also or they can be written also. So that is express, may be made in words, can be oral or they can be written. Then you have implied contracts. Okay? Implied contracts are those which are inferred from the behavior, the acts of the parties or the circumstances itself. For example, I make an offer to you through a letter. Correct? Now, I have made the offer to you through what? A letter. Letter means I have used words in the written form. And you give me your acceptance through a letter itself. Okay? So what is that? We have made the contract in the written express way. Correct? So, this is also a valid contract. Second is implied contracts, where words are not used, but contract has been entered into. How do you know? This is inferred from, that is implied from the behavior or acts of the parties. Let's take a very simple example. You are waiting on the platform. You have just got down from the train. You have your luggage in front of you on the platform. Okay, there is a coolie who comes. You can make out that he is a coolie because he is wearing the coolie's uniform. Okay, he comes and he picks up your luggage and starts walking. He has not said a word to you, nor have you said a word to him. Now, by his actions, you can get some meaning. And what is it? That through his actions of actually picking up your luggage, he has sent you a message here, or he has made an offer to you that I am ready to carry your luggage for you. Exactly. So he has made that offer to you in an implied manner. Now you want his services. You are saying yes to his offer. Now you don't even say yes. You start following him. Or the fact that you did not stop him and tell him, no, please put my luggage down. I'll carry it myself. What have you done by this? You have given implied acceptance through your action of following him or not stopping him from carrying your luggage. You have given him an implied acceptance. Correct? So that is a contract made in or created or formed in the implied manner, without the use of words, and it is a commercial transaction. It is a business. Business means it's not a social offer that he has made you, right? You are going to give him money in return for it. And then you have classification on the basis of validity or on the basis of creation. You have the third type, that is quasi contracts. Now, quasi contracts are actually not entered into by the parties. So far we have seen that contracts are formed by the two parties to the contract, correct, through a valid offer, acceptance, consideration, etc. Quasi contracts are not entered into by the parties. They are special types of contracts. These, under quasi contracts, the rights and obligations are imposed on the parties by law itself. So they are called as quasi contracts, and they are based on the principles of justice, equity, and good conscience. Those are quasi contracts. They are created by law and they are based on the principles of justice, equity, and good conscience. Let's take an example of finder of lost goods. Okay? You have found certain goods which do not belong to you. Okay, they belong to somebody else, and you have found them and you have taken them into your custody. Correct? Once you take them into your custody, you have become the finder of those lost goods. Now, the law is imposing a duty on you as finder that you must make efforts to find out the real owner. Till the owner is found, you have to take care of those goods. And once the owner is found, you have to return those goods to him. Then you cannot keep them. In return for this, the owner also has certain duties which he has to perform. Like in the attempt of finding him, in the attempt of taking care of his goods, whatever expenses you have borne, it is the responsibility of the owner to pay or compensate you for those expenses. That is his duty. Okay? So now this contract was not entered into by you or the owner, correct? These duties and rights were imposed on you by law. So such contracts are as quasi contracts. So when we do the topic, we will understand the various types of quasi contracts. So this is our classification on the basis of formation, creation or formation. Now let's understand classification on the basis of execution or performance. On the basis of execution or performance, contracts can be classified into 4 types. First are executed contracts. Executed contracts means where both the parties have performed their contractual obligations. Like when you go to the shop to buy a pen, you pay him the money, you have fulfilled your promise, he has fulfilled his promise, he has given you the pen. So the contract is over, it has been discharged. Nothing remains to be done. This is called as executed contract, where both the parties have performed their set of obligations. Then second, you have executory contracts, where parties are yet to perform their contractual obligations. Now actually executory contracts itself are of 2 types, bilateral executory and unilateral executory. Bilateral, bi means 2, correct? So bilateral executory means where both the parties are yet to perform their contractual obligations. So when I we both have entered into a contract and I tell you that I will deliver the goods to you next week and you promise to pay me for the goods after you receive the goods. I am going to give the goods to you next week. Have I performed my promise? No. It's going to be performed. And you are going to perform your promise when? When I perform. So have we both performed our promises as yet? No. Both of us are yet to perform our promises, correct? So that is bilateral executory. And then you have unilateral executory. Unilateral executory means what? Unilateral executory means, uni means one, where performance is outstanding on the part of only one party. Means one party has performed his promise, other party has yet to perform. Correct? That means I already made the payment to you for the goods and you are going to give the delivery to me. That is, your performance is outstanding on your part. You are going to give me the delivery after a week, but I have performed my promise. Okay? So that is unilateral executory. So this is classification on the basis of execution or performance. Now let's understand classification on the basis of validity or enforceability. So on the basis of validity, First, we classify contracts as valid contracts. Now, we already did this, essential elements of a valid contracts. What are valid contracts, or when will a contract be called as a valid contract? When it fulfills all the essential elements mentioned or given under section 10, section 29 and section 56, which we have already seen, correct? Only those agreements are going to become valid contracts. Second is void contracts. Void contracts are those which has no legal effect and cannot be enforced now in the court of law. Now here we need to understand that there is a difference between a void agreement and a void contract. Void agreement is that, void means that which has no legal effect, which is not legally enforceable, is void. Void agreement, now the word agreement means it has not become a contract. Okay? So when we say that minor is not competent by law to enter into a contract, correct? So he cannot enter into a contract. Now when you have entered into an agreement with the minor, is it enforceable by law? And subject to certain exceptions, it is not, correct? So that agreement with minor is void ab initio. Void ab initio meaning it is void since the beginning. It can never become a contract. That is a void agreement. Those agreements which are expressly declared as void by the Contract Act are void agreements. They can never become contracts. And then we have something called as void contracts. Means they became contracts. They became absolute valid contracts because they fulfilled all the conditions of section 10, 29 and 56. But after becoming a contract, something happened due to which now they cannot be legally enforceable. So they have become void. So they are called as void contracts. When they are made, they are valid. But after becoming a contract, due to certain reasons, they have become void. For example, A and B entered into a legal and valid contract. A has entered into a contract with B to sell him 100 kgs of wheat at a specific price. B has agreed to buy the wheat from A at that specific agreed price, correct? Now, they have entered into the contract. It's a legal and valid contract. But before they can perform this contract, when A actually has to pay and B actually has to deliver the wheat, before they can perform this contract, the government has changed or introduced a new law. And by this new law, the government is saying that wheat cannot be bought and sold by private individuals. If you want to buy wheat, you can only buy it from government agencies. This has not actually happened, but let's say that government does introduce a new law. Now, after the government has made this a law, can A and B buy and sell wheat on their own? No. Now what has happened to their original contract? It cannot be enforced due to change in the law. So now their original valid contract has become void. Now they cannot continue with it, and if they continue with it, it is illegal. Correct? Because the law has changed. So, after becoming a contract, due to certain circumstances, it cannot be performed in case of death of the party involving, where a contract is involving personal skill and talent. In case of breakout of war, in case of insolvency of the party, in case of impossibility of performance after it has become a contract, in case of change of law, due to any of these reasons, if after its formation it cannot be enforced by law, it is called as a void contract. Thirdly, you have voidable contracts. Voidable means those which can be avoided or repudiated or cancelled at the option of the aggrieved or suffering party. See, when I told you about free consent, I said that when parties have to enter into a contract, they have to do so on their free will, by their free will. They cannot be forced or coerced to enter into a contract. But let's say that you physically threatened me, okay, or you threatened me to physically hurt me and forced me to enter into a contract. Out of fear, I entered into the contract, but now I don't want to continue with the contract. Okay, now you used physical pressure, you used coercion on me. So I am the suffering party over here, I am the aggrieved party, correct? Now I say I want to avoid this contract. I don't want to continue with it. Why? Because my consent was not free. But did it become a contract in the first place? Yes, it became a contract. But after becoming a contract, can I cancel it? Can I repudiate it? Can I avoid it? Yes. That is called as voidable contract. Okay? So if my consent has not been freely taken, if I have been coerced, if I have been undue influenced, if you have committed a fraud and induced me into entering into contract, or through misrepresentation I have entered into a contract, then yes, I can avoid this contract. And those are called as voidable contracts. And you have unenforceable contracts. Unenforceable contracts are those which have some minor defect, technical defect in them. Once that defect is removed, they can become actual valid contracts. So for example, for a specific type of contract, that contract has to be signed and sealed, okay, or stamped. So it's signed, but it's not stamped. So till it is stamped, it will not be regarded as a valid contract. But once that technical defect is removed and it is stamped, it is going to become a contract. Okay. Then there are something called as illegal or unlawful contracts. Now unlawful and contract is very contradictory. They can only be illegal agreements, because if there is something unlawful in it, it can never become a contract. Okay? So here we have classification of law on the basis of validity. We have understood here the types of contracts under the Indian law on the basis of creation or formation, on the basis of execution and performance, and on the basis of validity and enforceability. Now, I hope you have understood what we have discussed in this first introduction and interaction of ours. Please do let us know your feedback, your suggestions on any content regarding this virtual class. Thank you very much.